Welcome to Spring Law's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. Spring Law is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Welcome, everyone. Thank you for joining us today. We're really excited to kick off episode 66 of our series, where we dive into the legal landscape for small businesses. So whether you're joining us as an HR professional, an in-house lawyer, or someone supporting a growing organization, today's session is designed to give you some practical legal insights for the 2025 and 2026 legislative landscape. I'm Jessica Paglia. I'm joined by my wonderful colleague, Shauna Fabrizi, and together we are going to break down some of the legal changes this past year, as well as some things that you can expect to see coming up in 2026. And before we get started, we have a land acknowledgement that I'll read out for everyone joining us today. We acknowledge that the land on which we operate is the traditional territory of the Anishinaabe, Haudenosaunee, Huron-Wendat, and Mississaugas of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous peoples lived and thrived here long before the arrival of settlers, and we acknowledge the lasting impacts of colonialism. And so as part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs, and we are grateful to live and work on this land. So in true fashion, we also have a legal disclaimer. I won't bore you with reading it. I'm sure we'll go over time if I do, but I'll give you a moment to review the next slide, and I trust that you will, and we'll leave it on the screen just for a moment so that you can kind of review it at your leisure. Okay. So now we will jump into an introduction of what we're talking about today, as well as an overview. So before we jump into the details, here's a quick look at what we're covering today. We're going to walk through the key developments impacting both Ontario-based employers and federally regulated organizations. And we're going to highlight what HR professionals and in-house counsel really should have on their radar right now. So we're going to start with Ontario updates. This includes new job posting rules, changes to leaves and layoffs, and key amendments under the OHSA and WSIA. Then we're going to look at some of the federal changes, including new leaves, as well as upcoming digital accessibility requirements to be mindful of. And then we're going to wrap up with a look ahead at our 2026 predictions and finish with some final comments, as well as any questions that might come up during the presentation. So with that, I will pass it off to Shauna to get us started with Ontario.
Thanks, Jess. So next we'll review some of the important 2026 updates from Ontario this year. First, let's dive into the first major change from Jan 1, 2026, the new job posting platform requirements. These rules don't apply to every employer or every job posting. They apply only to employers who are publicly advertising their job postings. So if you're sharing roles internally or relying strictly on referrals or closed networks, these requirements don't kick in. But for most small and mid-sized businesses using LinkedIn, Indeed, their own website, or any other public platform, this will matter. The second threshold is size. The employer must have 25 or more employees on the date the posting goes live. This means it's not based on annual averages or your highest head count of the year. It's calculated on the day you post the role. So if you're fluctuating around that 25 employee line, you'll want to be careful with timing and make sure you know which rules apply. We'll look in a moment at what these employers must include and update in their posting process. But for now, the key takeaway is this: if you publicly post roles and you're at 25 employees or more, these new requirements will apply to you starting Jan 1. So now is the time to review your platforms, templates, and internal approval workflow so you're not scrambling. Now let's look at the new job posting transparency requirements, also coming into force on Jan 1, 2026. These rules apply to employers with 25 or more employees, and they significantly change what must be disclosed upfront in a public job posting. First, postings will now need to include either an expected compensation amount or a salary range. And if you use a range, the spread can't be more than $50,000. That's designed to prevent those overly broad ranges that don't actually tell applicants anything meaningful. There is one exception. If the role pays more than $200,000 a year, the range requirement does not apply. Second, there's a new transparency rule around technology. Employers will have to clearly state if AI is used at any stage of the hiring process, whether that's screening, ranking, testing, or decision making. This is part of a broader push towards accountability and fairness in automated decision tools. Another important change is that employers will be prohibited from requiring Canadian experience in a job posting. This supports fair access to work for internationally trained candidates, and it aligns with existing human rights guidance. Job postings will also need to state whether the position is for an existing vacancy, essentially whether you're filling an open seat or you're building a pipeline. So this helps set expectations for timelines and urgency. Finally, there is a new requirement around follow-up. Any applicant who is interviewed must be informed of the hiring decision within 45 days. This doesn't have to be detailed, but it does have to be timely, and many employers will need new internal processes to ensure that communication doesn't fall through the cracks. Taken together, these changes are about giving candidates clearer, more meaningful information and creating more consistency in the hiring process. And next, let's talk about the new rules around extended temporary layoffs, which took effect on November 27th, 2025. This is a significant shift from the standard ESA timelines, and it gives employers a bit more flexibility, but only if all conditions are met. Under these amendments, a temporary layoff can now last longer than 35 weeks in a 52-week period, as long as it remains under 52 weeks within any 78-week period. So the window's larger, but it's still capped. To use this extended period, the employer and the employee must both agree in writing. And importantly, that agreement isn't valid unless the employee receives certain information before signing. They must be told the latest date they could be recalled, and that the agreement cannot be withdrawn once it's entered into. This is meant to ensure genuine, informed consent instead of pressure under uncertainty. There's also a new approval step. Employers must submit these agreements to the Director of Employment Standards, and the extension is only valid if it's approved. This adds an administrative layer that employers will need to plan for. Finally, employers must keep copies of these agreements for 3 years after they expire, so record keeping is going to matter here. Overall, these changes offer some breathing room during business disruptions, but they also come with strict procedural requirements. And missing any of them can convert an intended temporary layoff into a termination, which is very important. Now I will pass it over to Jess to continue with our Ontario 2026 review.
Thanks, Shauna. So another important update that came into effect on November 27, 2025 as well, is the new job seeking leave during mass terminations. So this one is particularly relevant for HR teams managing large workforce reductions. Under the new rules, in addition to the mass termination provisions that are currently under the ESA, when employees receive notice of a mass termination, and just as a refresher, this means 50 or more employees within a 4-week period, each of those employees automatically becomes entitled to 3 unpaid days specifically for job searching activities. So this could include things like attending interviews, meeting with recruiters, updating their own application or job documentation, or participating in job readiness appointments as required. So it's meant to give employees the space to transition to new work without being penalized. And employers can ask for reasonable evidence to support this leave. And reasonableness will likely depend on the type of activity and the circumstances as well. So just like other ESA leave-related documents, employers must retain all related records for 3 years. This includes any evidence provided as well as any internal notes associated with granting a leave. And the key takeaway here is anytime you're managing a group termination of 50 or more people, you're going to need to build this leave into your planning, scheduling, and communication of your employees. It's another procedural step that HR teams should be ready for. So next, we're going to review some new hire information requirements, which came into effect in the previous year on July 1st, 2025. These requirements also apply to any employer with 25 or more employees, and they focus on ensuring that new employees have the basics they need before their first day of work. So under these rules, employers must provide a written package that includes a few key pieces of information. First, the organization's legal name or operating name, along with the employer's contact details, which means address, phone number, and contact person employees can reach out to with questions. And you'll also need to specify the work location so that an employee knows where they're expected to report to and whether that is on-site, hybrid, or remote. The employer must also provide details about the employee's starting wage or commission structure, as well as the pay period and the pay day. And this is meant to create transparency from the outset so that employees aren't guessing about how or when they'll be paid. And finally, employers must include the initial anticipated hours of work. This doesn't have to lock you in forever into an agreed set of hours of work, but it does need to reflect what the employee should expect at the start of their employment to be their anticipated hours of work. So overall, these requirements are designed to promote clarity, reduce onboarding confusion, and set expectations clearly from day one. For many employers, it's a good reminder to review your onboarding templates and processes to ensure that this information is covered and included, especially in cases where you kind of have to fast track a hire or something like that. So next, we're going to review the long-term illness leave, which took effect on June 19th, 2025, this past year. This is a significant enhancement to job-protected leave for employees facing serious medical conditions. Under this new entitlement, employees in Ontario can now take up to 27 weeks of unpaid leave within a 52-week period when they're dealing with a medical condition that is serious and long-lasting. So this brings Ontario more in line with federal employment insurance standards, so the EI coverage, and gives employees much needed stability during these extended health challenges. To qualify, the employee must meet 2 conditions. First, they need at least 13 weeks of service with the employer. So an employee isn't able to take these leaves until they've had 13 continuous weeks of employment with you. And second, they must provide a medical certificate from a qualified health practitioner confirming the need for a leave. And the key message for employers is to prepare for longer protected absences and to ensure that your policies, your tracking systems, and your return to work processes as well align with these new timelines. And it's also a reminder to train managers on how to handle these requests sensitively and compliantly. So next, I'm going to pass things off to Shauna to wrap up our 2025 and 2026 Ontario updates. And then we'll move on to some upcoming updates in 2026 that are coming into force later this year.
Thanks, Jess. So before we get into the Occupational Health and Safety Act updates, we did have a great question come in, and that is, for a salary range, is a starting at acceptable, or do you need to have a range stated? So under the new changes, the job postings must include either the expected salary range, and if there is a range, the gap can only be within $50,000, or the expected compensation, a specific fixed number. So yes, saying that starting at $60,000 is acceptable as long as that reflects the expected compensation. You don't have to provide a range as well. It's either or, but you can't leave it open-ended or vague. And so the key here is that the applicant must be able to reasonably understand what the compensation will be. So I hope that answers that question.
Yeah, and I would add that even you know, it's either or, as Shauna had stated, and so even the just the amount, the expected compensation amount, might suffice. I would be weary of adding in conditional, you know, temporal conditions of like starting at this, or you know, expected to be increased, or something to allude that there will be you know, a different compensation amount than what is originally listed. Just be mindful that there is an obligation to provide a range if a range is applicable in that situation. So either, as Shauna said, the expected compensation amount or a salary range. Be careful of adding a lot of conditional language around those things. It might, you know, fog up the clarity between the either or.
That's a great point, Jess. So the starting at would apply, say there is a salary grid after a certain number of years, then the starting at is sufficient. But if it's not the actual starting range for the salary, then I would be hesitant at including it. So ensuring that it's either the exact number or you're providing a range. Thanks. Okay. So now let's turn to some of the Occupational Health and Safety Act updates. These changes broaden employer responsibility and increase the consequences for serious safety failures. So they're important for both HR and legal teams to understand. First, effective Jan 1, 2026, employers now have new duties related to the maintenance of washroom facilities. This is really about formalizing what should already be standard practice. So that's ensuring that washrooms are clean, maintained, stocked, and accessible. But because it's now a legislated obligation, employers ought to review their cleaning schedules, vendor contracts, and inspection logs to make sure they can demonstrate compliance. Next, the definition of workplace under the Occupational Health and Safety Act is being expanded to include virtual work environments. So this reflects the reality of modern work. Hazards aren't limited to physical spaces anymore. Employers will need to think about ergonomics, equipment, remote safety policies, and how to support employees who work off-site but still fall under the Occupational Health and Safety Act protections. Finally, amendments introduce a minimum $500,000 fine for repeat offenses involving serious injury or death. So it is a significant escalation in penalties, and it does signal a much tougher enforcement approach. And it's designed to push employers to proactively manage and monitor safety risks rather than react after an incident. Overall, these changes reinforce that safety responsibilities apply across all work settings, and the compliance failures carry real financial and reputational consequences. Next, let's now look at the changes under the Workplace Safety and Insurance Act. Although it's a short amendment, it carries significant weight for employers. And under the new rules, employers are now explicitly prohibited from making false or misleading statements to the WSIB in connection with an employee's claim. So while this aligns with what's already always been expected in practice, the legislation now attaches much more severe penalties for noncompliance. What this means is that employers need to be extremely careful about the accuracy of any information submitted, whether it's about the nature of the injury, the employee's duties, availability of modified work, or any details that could influence the claim. The goal here is to strengthen the integrity of the WSIB system and ensure that claim decisions are based on truthful, complete information. This is a good reminder to review internal reporting processes, make sure supervisors understand their obligations, and double check that all WSIB communication is consistent and well documented. So that now brings us to a look at what's on the horizon for Ontario. Changes that have been proposed but are not yet in force. Specifically, next, we're going to look at the upcoming potential placement of a child leave, which will apply in cases of adoption or surrogacy. And this new leave will give employees with at least 13 weeks of service the right to take time off when a child is placed with them, recognizing that adoption and surrogacy come with many of the same demands and transitions as birth-related leaves. Employees will be entitled to up to 16 weeks of unpaid leave. And what's helpful is that the leave can start up to 6 weeks before the actual placement. That gives families the ability to prepare for the transition, attend required appointments, and manage the logistics that often come with these processes. It is important to note that these changes are not in effect, but they're expected to move forward. So employers should begin thinking about how this will fit into their leave policies and how to integrate it with existing parental and family-related leave entitlements. Next, I'll pass it over to Jess to walk us through some of the federal updates.
Thank you, Shauna. So now we're going to shift gears, as Shauna said, and we're going to look at what's happening at the federal level. So just like in Ontario, we're seeing a wave of changes aimed at expanding employee protections and increasing transparency. And these updates are especially important for employers in federally regulated sectors or anyone who supports clients who fall under the Canada Labour Code. So just to be clear, this is, federal employers, but it's also good for provincially regulated employers, such as those in Ontario, to be mindful of these changes, as all of the legislative changes that we see in the employment sector are intrinsically involved and do influence, each of the different provinces and federally. So now we'll walk through the key new leave entitlements, the evolving digital accessibility requirements, as well as what HR and legal teams need to prepare for as these changes come into force. So with that, we'll dive in to the federal landscape with the new federal leave entitlements, which came into effect on December 12th, 2025 under the Canada Labour Code. And these changes are quite significant for federally regulated employers. First, we have the new pregnancy loss leave that was enacted, and this provides up to 8 weeks of absence in the case of a stillbirth, and this recognizes the immense impact of those experiences. And for any other form of pregnancy loss, employees are also entitled to 3 days of leave, the first 3 days being paid for employees who have at least 3 months of service. And this is a major step forward in acknowledging the need for time, privacy, and support during these situations. So next is a modification to the bereavement leave, which did previously exist, but now the entitlement is being expanded to 8 weeks, which aligns with a broader approach to providing more substantial time off for significant losses. And this change reflects a growing recognition of the emotional and practical demands that follow the death of a loved one. And finally, the new leave for placement of a child is being introduced at the federal level. And similar to the Ontario change that Shauna went through earlier, federally regulated employees will now have access to up to 16 weeks of unpaid leave when a child is placed with them through adoption or surrogacy. This is meant to align with the upcoming EI program changes and is designed to give families the time that they need to prepare and transition. And these changes mean federal employers will need to revisit their policies, update their handbooks as necessary, and prepare their managers for the new entitlements and what these mean, and that they go well beyond what had previously existed. So next, we're going to look at the equal pay for equal work rules coming into place in fall 2026. These changes are designed to ensure that employees doing the same work under the same conditions are paid the same, regardless of their employment status. And what this really targets are situations where part-time, seasonal, fixed-term, or temporary help agency workers are paid less than full-time permanent employees, even though they're performing substantially the same job. So this doesn't mean paid less overall, this just means paid less, when prorated. So under the new rules, that kind of differential will be prohibited unless there is a legitimate, non-discriminatory explanation. So explanations for any differences could be things like seniority, merit, or any clearly defined production-based system. Employees will also have the right to request a review of their wage rate if they believe they're being paid less than someone doing the same work. And when that happens, the employer is obligated to respond and provide a written response within 30 days. That response must either explain the difference in pay using valid criteria or provide a plan to increase the employee's wage to bring them into alignment. And so this introduces a new level of transparency and accountability around wage practices. Employers should start reviewing their compensation structures now, especially where different employee categories are performing the same function, so that they are prepared when these provisions take effect to reason these changes accordingly. So next, we will review the upcoming right to disconnect requirements expected to take effect in fall 2026. This is going to be a major change for federal employers as well, especially those with knowledge-based or remote workforces. Under this new framework, employers will be required to have a written policy that clearly defines expectations around work-related communication outside of an employee's scheduled hours. This includes outlining what disconnecting means in practice, when communication is permitted, and any exceptions, for example, in emergencies, on-call roles, or senior leadership duties. And then just generally the rules that employees and managers are expected to follow as it pertains to communication outside of an employee's scheduled hours. Once the legislation takes effect, employers will have 1 year to come into compliance, so 2027 fall, which means a full year to develop the policy, consult internally, train managers as required, and ensure the organization is aligned. And so although the specifics of this are still evolving, the goal is clear: to support healthier boundaries around after-hours work and reduce the expectation of constant availability. And this is very familiar for our Ontario HR representatives and in-house lawyers as well, because Ontario, as you may know, has very similar legislation requirements. So this is another example of the federal, the Canada Labour Code coming into alignment with our provincial standards as well. So some other additional Canada Labour Code updates coming in 2026 that federal employers can have on their radar. These aren't as high profile as new leaves, but they will still require adjustments in workplaces across federally regulated sectors. First, we're expecting new noise level reductions. So this will mean updated standards for exposure limits, monitoring, and protective measures, especially in sectors of transportation, aviation, shipping, machinery, and other higher risk environments. So employers should be prepared to review their noise assessments and mitigation plans once the details of this legislation are finalized. Second, we'll see an updated first aid kit requirement. This usually means changes to what must be included, how supplies are stored, as well as how often they're inspected or replenished. And this is a good reminder for employers to audit their existing kits to ensure their first aid training is current. And finally, there will be personal protective equipment updates. These changes are expected to modernize the PPE standards that are currently in place. They will ensure that equipment reflects current safety science and is appropriate for a wider range of workers. So employers may need to revise their procurement practices as well as their PPE training in order to stay compliant. So nothing here is in force yet, but all of these updates, are for your knowledge, and they signal an ongoing push toward stronger health and safety protections across federally regulated workplaces. So now I will pass it over to Shauna to bring us home with a final federal update and some practical guidance going forward.
Thanks, Jess. So finally, let's look ahead to the new information and communication technologies requirements, for which the first round of obligations will be applicable as early as December 2027. These rules will apply broadly across federally regulated organizations, but the obligations scale depend on employer size. They'll cover federally regulated private sector employers with 100 or more employees, those with 500 or more employees, as well as public sector organizations. Each tier will have slightly different expectations, but the core focus is the same, which is improving digital accessibility. Under these changes, organizations will need to ensure that their websites and mobile applications meet modern accessibility standards, meaning that content must be perceivable, operable, understandable, and robust for users with disabilities. There will also be requirements around staff training, particularly for anyone involved in developing, maintaining, or procuring ICT systems. And organizations will be required to publish accessibility statements outlining their compliance status and how they're addressing barriers. This is a significant shift for many federally regulated employers, and it mirrors the broader movement toward inclusive digital design. The timeline gives organizations some breathing room, but the work involved, especially for larger employers, will require planning well in advance. And in terms of practical guidance, so what's next? Now that we've walked through the major Ontario and federal changes, let's shift to what this actually means for your day-to-day operations and what you should be doing now to get ahead of these updates. So the first step is to review and update your internal policies. Many of these changes will require changes to internal handbooks, onboarding materials, hiring templates, and internal workflows. Next, you'll want to audit your current practices, looking at how you advertise roles, how you handle leaves, how you manage layoffs, and how you communicate with employees outside of scheduled hours. Any gaps now will become compliance issues later. It's also a good idea to train managers and HR teams early. A lot of these changes do require precise communication. And whether it's informing applicants within 45 days, understanding and applying new leave entitlements, or applying equal pay rules, your frontline supervisors should know what's changing and what to do in specific situations. And finally, consider building a transition plan, a roadmap that outlines who's responsible for each update, when policies need to be revised, and how to communicate changes to employees. These changes span multiple years, so a proactive timeline really is your best friend. And in short, the goal is not just to stay compliant, but to stay ahead. So your organization is prepared, it's consistent and confident as these new requirements come into force. And finally, as we wrap up, we will get to some of the questions that have come in. Before we do that, we want to leave you with two of the most practical and impactful steps for managing risk and staying compliant as all of these changes roll out. First is making a point to conduct regular policy reviews and training for HR and also for managers and supervisors. Many of these new requirements rely heavily on managers understanding what they can and can't do. Regular refreshers go a long way in preventing accidental noncompliance. Second, maintain clear, consistent records. Almost every one of these new obligations comes with a documentation requirement. Good record keeping is your best defense if questions arise and your easiest path to demonstrating compliance. Taken together, these two practices, staying current and staying documented, are what will help employers navigate these changes smoothly and confidently. And so we had a couple of excellent questions come through that I'd like to address. And the first one is the previous slide with washroom. Can you review what was meant when it stated expanded to a virtual environment? So that's referring to the ESA's existing protections for employees' rights to access a washroom, which were initially geared towards physical workplaces, but are now being interpreted or extended to virtual or remote environments. So in practice, this means that if somebody's working remotely or in a non-traditional setting, for example, gig workers or mobile workers, the employer still has to take reasonable steps to ensure that they have access to washroom facilities during work. So it's not about providing a washroom in their home. It's about situations where a remote or mobile worker might otherwise be denied washroom access. So what comes to mind could be delivery drivers, temp workers, etc. And the change just modernizes the application of the rule to fit new work environments. It's not a huge change for traditional remote workers, but it is relevant for non-office settings where access is not guaranteed. And the next question was about adoption leave. So can you confirm that this is in addition to parental leave? And so, so this is a new entitlement. It does, it specifies, the Act does specify how it interacts with parental leave.
Yep.
And so
I can jump in here, Shauna, as well,
sure.
if you'd like. Yep. So just in reviewing this question, I kind of confirmed in the background as well that this is in addition to the parental leave that is already available. And this adoption leave is meant to mirror the 15-week maternity leave that birth mothers get. And then, it's just meant to include those who are preparing for or facilitating adoption or placement of a child, that they are able to have, the supporting time to arrange their affairs accordingly, similar to the maternity leave that's already in place. So next I see a question that came in regarding salary transparency. So the Ontario rules that came into effect January 2026, is the 200,000 specifically applied for base salary or OTE? So, in reviewing the legislation that this comes from, compensation is the referred term when talking about these salary ranges. And so, in the Ontario regulation itself, the compensation is defined as wages. And so we have to kind of turn to the ESA and what is wages? Well, under the ESA, wages is any monetary, remuneration payable by an employer to an employee under the terms of an employment contract. But there is case law that explicitly includes, and the legislation as well has reference to this, that it specifically excludes any sums paid as gifts or bonuses that are dependent on the discretion of the employer, and that are not related to hours, production, or efficiency. So, to try and summarize quite a disputed area of the law in classifying what is wages and what is discretionary and non-discretionary for bonuses. If the job that you are posting has a base salary as well as a non-discretionary bonus that brings it above that $200,000 threshold, then there is a good chance that it will be exempt from the wage listing requirements. But it really turns on whether the bonus is considered a part of wages and whether this is discretionary. So if the company has any input into whether this employee receives their bonus and whether it balances on anything other than, very straightforward, the person's hours, production, or efficiency measured and, very strategically outlined at the outset, then I would be wary about this exclusion, applying this exclusion, especially if you're falling at an expected base salary of, say, anywhere between like 170 to 190, like right under that threshold. I would be very wary about ensuring that the compensation is non-discretionary entirely, that you're factoring into this compensation amount. So, feel free, if you have any specific questions on that, to reach out to us directly. We're very, very happy to help out on those things. Shauna, do you have any further comments on that?
Yeah, I would echo what you've mentioned, which is that the on-target earnings, it does typically mean base salary plus expected commissions or guaranteed incentives, so not discretionary. And I think this would generally be included in the calculation as long as they are part of the employee's contractual compensation. And as you said, just not discretionary.
Yes. So I see a question that came up when referencing how the federal updates apply to federally regulated employees. Does that mean it's not applicable to private companies? So great question. And I'm going to go over kind of what federally regulated means and how it's defined and applied. So federally regulated employees are employees who work for federally regulated employers. So these are things, these are employers such as banks, airlines, railways, telecommunications companies, federal crown corporations, any interprovincial transportation or shipping dependent on certain, certain applications of the jurisdiction. So it is a very specific distinction of whether an employer is federally regulated or provincially regulated. and it would be in accordance with your sector. We also see some caveats to this generalization, such as investment firms under a bank umbrella are provincially regulated rather than federally in some cases. So we do see distinctions in this regard. But if you're a company that is not in a federally regulated sector, such as a provincial private employer, you're covered likely by provincial legislation. And if you would like, an assessment of where your company falls within that range, that broad range of federal versus provincial, we can always assess on a case-by-case basis and provide some guidance as necessary. Shauna, do you have anything to add to that?
No, that's great. That's great. So I think that's all of the questions that we received. And so that does bring us to the end of the formal presentation. And as always, we'll share additional resources after the session. So that includes links and a summary to help you stay on track with your compliance planning.
Yes, and we would like to give you a heads up about our next episode as well. So episode 67 will focus on the tax and employment implications of mergers and acquisitions. This is a topic that comes up frequently for both HR and in-house legal teams, especially as organizations navigate restructuring and growth. It's quite a daunting topic to kind of navigate. So this episode will be very informative, I'm sure, for a lot of people. And so this session is going to be taking place on Wednesday, February 18th at 10:30 a.m. We'd love to have you join us for that conversation. So keep an eye out for those registration details. And thank you everyone again for joining us today.